Leanne Cusack's next guest, here to help families dealing with breakdown. Leanne.
Yes, Graham, Tanya Davies is a family lawyer who joins us regularly on the program to talk about custody, support, separation, and divorce. She's here today to answer viewer questions. Hi, Tanya.
Hi, Leanne.
First question is, I have full custody. Does my ex-girlfriend have to pay child support? You're used to having a variety of questions presented. What's the answer to that one?
So the word custody, Leanne, actually refers to decision-making for the child, and custody never determines payments of child support. What determines that is primary residence. So if the child is primarily residing with you and your ex is only getting access, she needs to pay support. If you're in a shared parenting arrangement, we'll look at both parties' incomes, and then the parent with the higher income would pay a set-off amount of support.
It sounds fairly formulaic, and I'm sure you see it all. Next question, can I get child support without a custody agreement?
You certainly can if your ex is agreeing to pay child support on consent. However, I always tell my clients you need a written agreement. You cannot enforce something that is verbal. Maybe your relationship is good now, but down the road it will change. And then you would be pursuing, if you have no agreement in writing, you would be pursuing child support in court.
Well, this actually leads into our next question. Question 3. I'm trying to put together an agreement with my ex about our child, and I don't have a lawyer. What are some of the things I should put in the agreement? What's your advice on that, Tanya?
I would say from a lawyer's perspective, Leanne, you need to get a lawyer right away. Agreements that are drafted essentially on a piece of napkin at the kitchen table could be easily set aside. And as a lawyer, I would never recommend it. If a client comes to me asking me to draft the agreement, obviously if they have children, custody and access would be included in the agreement. Child support would flow from that. If there is a disparity in the parties' income, spousal support, and of course, division of property.
And I guess the document is important because emotions change over time, circumstances change over time. And so to have a legal document does make a difference. In our final court order is the next question. It says, I cannot change the name of our child, but now our child who is 12 years old wants to change his last name. What do I do?
So you need to approach your ex and actually have a conversation and say, this is what our child wants. And if you're on good terms and if you speak to the child directly, you need to know the reasons as to why they're changing their name. So if it's all on consent, you can draft a consent order that the child's name would be changed. But you need to look at the reasons as to why the child wants that name change. So for example, if one of the parents' names is being removed and the child could be influenced by one of the parents, I always tell clients that you need to be very careful about influencing your child for your own benefit. I actually we argued a motion recently where the judge reversed primary residence at an interim motion because she saw parental alienation. So you have to be very careful if you're manipulating your child to change their name, let's say to the primary residence parent's last name for the wrong reasons.
Okay, thank you very much, Tanya. We can't get to the rest of the questions, but we'll save them for your next appearance. And we have a link to Tanya on our website. Thanks again.